This is a legal passage which I'm going to dictate you. 5 seconds to go. Get ready, start. Accordingly, the Larned Trial Court had passed an order dated 24/11 in TS number 247/2002 directing the appearance of Sri Ashok Kumar Sen pursuant to order passed in miscellaneous case number 218/11. The trial court passed another order dated 11/11/2011 in TS number 247/2 allowing the petitioner herein to take steps to call for documents containing signature of Sri Ashok Kumar Sen from Indian Overseas Bank, Panbazar, Gauhati. In respect of Section B, account number 3780, para, while the above referred order were passed by the Larned Trial Court on 22/2/2011, 24/2011 and 11/11/2011 to call for documents containing signature and writing for comparison, the director cum chemical examiner void letter dated DFS 1208/2010/2022 dated 13/10/2011 had forwarded his opinion number DFS/QDS 266/10 dated 26/9/2011 in connection with TS number 220/2011 and TS number 247/2002. Thus, the said opinion was without considering the documents which the Larned Trial Court had ordered to be called for. Para. It is seen that by the order dated 7/1/2012, the Larned Trial Court had not recorded its satisfaction on the FSL report 26/9/2011 as forwarded by the letter dated 13/10/2011. It is also seen that the Larned Trial Court had recorded that there was no necessity to call for documents from Indian Overseas Bank at that stage. Hence, by order dated 11/4/2012, the Larned Trial Court had erroneously concluded that by order dated 7/1/2012, the court had recorded its satisfaction on the FSL report and had dispensed the requirement of document to be called from Indian Overseas Bank. The relevant part of the order dated 11/4/2012 is quoted below. In the instant case, it is found that court has not expressed any dissatisfaction as regard the report. Rather, the court has expressed satisfaction on the report submitted by the FSL and as such opined that there is no necessity to call for the documents containing signatures of Ashok Kumar Sen from Indian Overseas Bank as called for by the authority, as the report has already been received. In such circumstances, I am of the view that there is no merit in the petition and accordingly the petition is rejected. Para. The Larned Trial Court, Fight Order dated 17/7/2012, had recorded that from the date of the order issued in TS number 220/2000 since 7/10/2012, the date on which the report of the FSL was received, the court had not passed any observation regarding satisfaction or dissatisfaction on the report of the Director FSL. Para. Later on, recognizing the said error, the Larned Trial Court had passed an order dated 3/1/2016 to allow the parties to advance their submission on veracity from the report of the commissioners, along with other submission on this case. However, by order dated 19/11/2016, it was inter alia held by the Larned Trial Court as follows. Para. It appears that there is nothing on record to indicate that the court was dissatisfied with the proceedings of the commissioner, and as it is implied that the court was satisfied with the proceeding of the commissioner, otherwise it would have directed further inquiry as provided in sub-rule bracket 3 above, citing reason for its dissatisfaction with the proceedings of the commissioner. So situated, I am of the opinion that no further inquiry as per sub rule 3 of the rule 10 of order 26 is required to be made now. Accordingly, this query is set at rest. Now the learned counsel of the plaintiff hereby asks to advance his argument as a whole. Para. Therefore, from the above discussion, this is not a case where the expert opinion by the director cum chemical examiner Bhide opinion number DFS slash QDS 266 slash 10 dated 26/9/11 as forwarded Bhide letter dated DFS 1208 slash 2010 slash 21 dated 13/10/2011 was in conformity with the letter dated 24/10/2010 by the Director FSL or order and direction dated 22/2/2011, 24/2011 and 11/11/2011 passed by the learned trial court in connection with TS number 220/2000 and TS number 247 to call for document containing signature and writing for comparison. Scientific investigation are covered by the provision of Order 26 Rule 10A CPC. Therefore, as the said order dated 22/2011, 24/2011 and 11/11/2011 were passed by the learned trial court at the request made by the Director FSL by letter dated 24/12/2010 to send document containing signature and writing for comparison. The scientific investigation culminating in the report dated 26/9/2001 was in contravention of the said request made by the Director FSL for additional signature. Therefore, this court does not find any infirmity with the prayer made by the petitioner for examination of the documents by the government examiner of questioned documents at Kolkata. Para. Under the circumstance as projected in the case in hand, the court cannot take a myopic view of the entire matter because even upon cross-examining the expert, the petitioner did not abandon the plea on dissatisfaction of the commissioner's report as submitted by the learned senior counsel for the respondent numbers 1 to 3. This court is of the view that even without challenging the order dated 11/4/2012, no infirmity is found in the stand taken by the petitioner to obtain an independent opinion by the government examiner of questioned document Kolkata. This court finds sufficient force in the submissions made by the learned counsel for the petitioner that the FSL had given its report by ignoring their letter dated 24/12/2010. Hence, this court cannot accept the submission made by the learned senior counsel for the respondent number 1 to 3. Para. The cross-examination of the senior scientific officer, Question Document Division, Directorate of Forensic Science, Assam, pursuant to order dated 17/7/2012, passed by the learned trial court in TS number 220/2000, does not obliterate the requirement expressed by the learned trial court by its subsequent order dated 22/2011, 24/11 and 11/11/11 passed for call for documents containing signature and writing for comparison. Stop. Thank you.